Lauda, Programs and Outreach Manager at Southeastern New York Library Resources Council. Thank you for joining us for today's webinar, AI on the GLAM job. So before we begin the program, I just have a few housekeeping notes. Because of the overwhelming interest in today's webinar, over 150 people registered. We're using Zoom webinar. Also, side note, it means that we accidentally crashed our website when we sent you the handout. So Claire is going to drop a new link to the handout in the chat. Apologies for that. It also means that you are only able to see the presenters and the hosts, and we're the only ones with microphones and cameras enabled. So to participate, you can use the chat, and we encourage you to do that. You can introduce yourselves to the others right now. Just make sure your comment goes to everyone and not just panelists and hosts. We also want to let you know that we will be taking questions. So if you have a question during the meeting, please use the Q&A feature rather than the chat so it doesn't get lost among any other comments that might come through. This webinar is scheduled to run until 11 o'clock, but we'll probably hang on until 11:30 in case there are more questions that come up at the end of the presentation. As you can see, we are being recorded, so if you have to leave, you can catch up on the recording after the fact. So I want to remind you that we've got automated captions with Zoom. So to view them, just click on the show captions icon on your Zoom screen and click on the caret to see more options. I also want to remind you that all attendees are expected to follow Southeastern's Code of Conduct, which will be added to the chat shortly. In short, please treat all staff, event attendees, and speakers respectfully. Those who do not adhere to the Code of Conduct will be removed from the meeting. We are recording today's event, and we will make the recording available to you as soon as we can upon the webinar's conclusion, most likely sometime early next week. We'll send you a link, a form to evaluate this panel discussion, and a request for a certificate of attendance. We will also share a link to the other webinar that Cole will host for us in 2025. So I'll be in the background here throughout the meeting. We also have Claire, who's listed as ESLN Tech Help. So please contact me or her if you have any technical assistance needs. So I am now very happy to turn the meeting over to Stephanie Cole Adams.
All right. Thank you, Carolyn. Hello, everybody. Happy Friday. I don't know about you all, but it has felt like a very long week, and I'm looking forward to spending just a little time with you, talking about something just normal and new and exciting, AI. I guess not super new, but nevertheless evolving every day. The lens of this presentation, because this is an Ask HR presentation, is how this impacts your institutions. And we went with galleries, libraries, and museums, but of course, really, we're going to have something for everybody who might be a library council member. Yeah, the lens is through HR. And so how this impacts as an employer. But we will be talking about how it affects the workers and your day-to-day experience. So we're going to approach different developments from all of those perspectives. So for those of you who don't know me, I'm an attorney in Buffalo, New York. Joining me from my office is paralegal Kirsten Anderson. She'll be watching the Q&A. Please drop your questions into the Q&A, and feel free to even start putting them in now. If there's something that you want to make sure you hear answered on this topic over the next hour, put that in there, and Kirsten will sift that out and interrupt me at the time she deems appropriate to make sure we talk about that. And I'll just mention, because I like to talk about, well, you know, what experience in my career brings me here to discuss this topic today. I do a lot of human resources work, both for libraries and for other organizations. I got my start in part focusing on intellectual property and technology law in the very early 2000s. And so I've been following tech issues for quite a long time. So we are going to have there's a lot of words in today's slides, and I will mention, if you can't get to the handout, the slides that we're going to be reviewing actually have pretty much all the same content as the handout. So you won't miss anything if you don't have the handout in front of you, as far as being able to refer to something I'm talking about in the moment, but it does have some template language as well, in a format that you can export later, and you're authorized to use that. And then we do have some pretty pictures just to give you something else to look at while we are looking at the different laws regarding AI and impacting employers. So here we go. The first thing I want to mention is there's a lot of writing out there on AI, and I don't need to tell an audience of information management professionals how to find information. But I will refer to, I want to just set the table for you about how I approach this. I'm going to be reading, I have not finished this book, Co-Intelligence by Ethan Mollick. But Ethan Mollick has 4 principles that he reviews in this book. This is not an advertisement for the book, nor for Penguin Random House, but I like to give credit where credit is due. And just so you know how I'm approaching these issues, because I know a lot of attorneys who are very opposed to AI, and I know some attorneys who are thinking that if you're not using AI in a law firm, if you're not using AI in the workplace, then you're basically not working up to par. I try to bring a blend of caution and diligence and optimism to this topic. And I think that is distilled in this book because there are 4 principles that I just want to review, which is number 1, always invite AI to the table. In other words, don't simply say, we don't use AI. And that's one of the lenses I'm going to be approaching this topic through today. However, and I really appreciate this phrasing, be the human in the loop, meaning you start with human and you end with human, even if you are optimizing human capability by using AI. And I think you're going to see that a lot of the law that we will be reviewing today actually approaches this topic from that perspective. The next one is treat AI like a person, but be aware of what kind of person they might be. In other words, it might be flawed, but they also have the AI has a role to play, right? Just like all of us. And this was an interesting 4th principle. Assume the AI you're currently using is the worst AI you will ever use. And I think that guidance is really to continue a spirit of optimism in using AI, but also wariness and realizing it is a tool. At the end of the day, it is a tool to be used. We can certainly get together and debate when the AI becomes sentient, right? Will we be able to say things like it's just a tool? Topic for another day. Watch a Star Trek. We're not going to really go down that road. But I'm just going to be referring to those 4 principles as we go forward. Because of that, each one of you attending the session has a variety of code of ethics. Many of you will be following the ALA code of ethics, museum-specific codes of ethics, etc. This session is not going to review specific ethics that pertain to your professions and use of AI. And also in this session, we're not going to showcase particular AI or talk about, what AI to use or what to avoid. We're going to talk about the legal definitions and some of the legal parameters that are emerging around AI. And my observation is that what we're going to review will help you in your own work to evaluate AI and to make well-developed and well-documented decisions about when to use it, how to use it, and how to develop policy around it. So that's my goal for you for today. Hopefully we're in alignment on our goals. So for those of you who have the sheet in front of you, we're going to start with our 3rd factor, because our first 2 was not really going to talk about ethics, not really going to talk about specific products. But this is a really important one. Number 1, we have a recent Supreme Court, or not Supreme Court, it hasn't gotten there yet, sorry. We have a recent court decision from the federal courts that has confirmed that AI in and of itself cannot own copyright. For those of you who work with copyright a lot, you know that in order for something to be protected by copyright, it has to be an original work of authorship. So when I wrote this this handout today, well, I didn't write it today, but when I wrote the handout for today, I generated this, and you will see that there is a little copyright notice on the bottom, claiming my authorship, and it is an original work of authorship, although it certainly quotes a lot of law in which I do not claim the copyright. I have brought it on either under fair use or because it is not actually subject to copyright. And I own that copyright. Now, if an AI acting, what this case means, if an AI acting of its own devices had created this exact same presentation, I would be out of a job. No, just kidding. But if the AI had simply generated it sua sponte, as we say, out of the clear blue, it would not be subject to copyright. If I had used AI in generating this document, which I did not, I probably should consider using AI for some of these things, but I don't. Um, then I, as the person who used that tool, but was the human at the beginning and the human at the end, right? Remember, be the human in the loop. Um, I would own the copyright, even though I used an AI tool to generate it. There's a lot of ethical discussion going on out there about the use of AI to generate original concepts and works of authorship, especially in the field of art, because a lot of AI, of course, pulls from the intellectual property of others to then generate something new. A person who might, hit a button and issue some unique commands and use the AI as a tool to generate something that they would then claim authorship of. Again, that is an ethical debate that's beyond the scope of today's discussion. However, I will say this: where does this come down in the employment, right, as an HR factor? So if your employees, and this is really for leadership who's listening, if your employees are using AI to generate things that should be owned by the institution, it's really important to have some policy language to guide that. And it really does relate back to being the human in the loop. So if you take a look at factor 3, and again, this language is right here on the slide. Some suggested language to confirm this is to ensure quality control and assurance of copyright ownership when using AI to generate material for use by whatever your institution is. Employees must note the use of the AI, and an employee must be the last entity to review the content. It's really important to remember that at most places, the default is going to be that if the employee generates, again, a presentation, an article, a libguide. This is a frequent topic in libguides. If there is no other policy, then the employer is going to own the work, is going to own the copyright to the work the employee generated as part of their job. That is a copyright 101 thing. Many places, particularly educational institutions, have a different policy that will say, especially for faculty own their own work, even if that work was created as part of their employment. So it's important to know from, the takeaway here is it's important to know what is the current approach that your institution has to employee generated intellectual property. And again, presentations, articles, libguides, etc., websites, social media content, right? And then what is going to be the policy when an employee is using AI to generate that? So, and you can appreciate, I even put in here to ensure quality control. There's a lot packed into that, including avoiding copyright infringement. So, and this is just the notice that, right, the copyright ownership is going to depend on the approach of your institution to employee generated content. All right, factor 4, and I'll pause 1 second. Do we have any questions on the copyright? Because we're gonna move on. But all right.
We just got a question.
Okay, I'm gonna back the slide up. Go ahead.
Good morning. If I were to use AI to create an image for a book display at my employment, do I potentially own the copyright or does the institution?
Yes, that is exactly what I was talking about. So if the institution does not have a policy, or there isn't a term in perhaps a hire letter or even an employment contract. Most people who work for libraries tend to not have employment contracts, but some do. Some might also be subject to a collective bargaining agreement. If there is nothing that says otherwise, the default is that anything that is generated by the employee as part of their job, not what they do as a hobby when they go home in the evening or what have you, but as part of their job, is owned by the institution. That is a really important question to have asked. Thank you to the person who asked it. And if you think about it, it's really important. It's always been important for an institution to know where they stand. Again, if they haven't defined a stance, then the default is that the institution owns the property. For those of you who are, if you are ever negotiating your own employment contract, this is something to keep in mind because it is a point that can be negotiated. You could have something in your letter that says, if I write an article as part of my job as, the executive director or the head of this division, I'm going to own the copyright. That is something that can be in a contract. We could spend hours on that, but that's just a little pro tip to take away. But it's really important to know the lay of the land because as you can see, it's difficult to enforce this aspect about the ethical and careful use of the AI unless you know where the institution stands. I will also say, and I alluded to it in the quality control piece. It is important that whoever is using, so I like that example, using AI to generate a display. It's important that the end product still respect copyright and trademark law and not be defamatory. All the things that are important if a human is doing 100% of the work, it's still important if AI is a tool that's generating a significant part of the work. And that's where remember those principles in the Moloch book, always having the human in the loop, right? At the end of the loop. Okay. All right. So
Follow-up question.
sure, yeah.
If that is the case, can I list myself as a creator on a resume?
Yeah, so there's a lot of workarounds. So I would say, unless there's a policy saying differently, I have to give the lawyer disclaimer, right? But claiming claiming authorship is perfectly appropriate. I believe, again, an institution might have a policy that says different, but I think, especially on a resume, if you worked at an institution where you helped create, perhaps you curated an exhibit or you wrote articles, those articles are publicly accessible, that content is accessible, and you were accurately saying, I wrote this, I created this, the act of creation, who is the person who did the creation, might not be the entity that owns the copyright. So yes, I think, barring, again, a policy that says otherwise, claiming creator credit is perfectly appropriate. It's just distinct, right? As we've just reviewed, it's distinct from copyright ownership at times.
And can contract language be created where the copyright is shared by the institution and the individual?
Yes, great question. Yes, absolutely. And I would say I'll just add and this is really a people at higher ed thing, but it could be anywhere. If you're at an institution where you're frequently collaborating with maybe other co-authors, it's important to have contract language that talks about, how is the ownership handled? The default in copyright is that if you have 3 people who own a joint work, any one of those people can license that work potentially without the consent of the other 2 owners or however many owners there are. So it's kind of like it's kind of like you have to have a partnership agreement almost to say, okay, we're going to do this together, and here's how, once the work is created, here's how we're going to manage it together. Okay, so number 4. So the state of New York, now there's a lot of federal law on AI as well, but because we're coming at this from that HR lens, and most employment law in New York is going to be governed by New York state law, New York labor law, New York contract law, all that. It is important for us to focus a little bit on the fact that New York has defined AI. And so for your institutions, especially when it comes to HR manuals and policies that you really want to drive employee conduct, it's important to use a definition that is consistent with the definition in New York. Now, that's the good news. You have a definition to work with. The bad news is, as you can see, it's long. And it's fully reproduced in section 4, but it is long. But there we go, right? Machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments. And in New York, we're focusing on what is that can directly impact the public. Now, of course, for everybody here, you are at an institution where your work is directly impacting the public. You are serving the public. So this definition ties right into things. And then it talks about artificial intelligence systems, which are machine and human-based, use machine and human-based inputs to perceive real and virtual environments, et cetera, et cetera. So you have this definition of artificial intelligence systems to work with. And it includes machine learning, large language model, natural language processing, computer vision technologies, et cetera. And that's and including generative artificial intelligence. We only have 60 minutes today. We're not going to get into the different subsets of AI, but it's important to realize that, of course, like anything, there's different types of AI within that large umbrella category. And the law does contemplate that. So now this is a really important one for all of the members, libraries, and other institutions that fall under civil service. So I don't want to say everybody else, you can take a little bit of a break. This might be time to go warm up your coffee, but this particularly pertains to civil service. So public libraries, other institutions that have civil service employees. This is going into effect this summer. So the use of artificial intelligence systems as defined by the state technology law. So the definition that we just looked at. So that's how these things interplay. So it's very important to use that definition, as I mentioned. And now it's important to keep this in mind. Shall not affect the existing rights of employees pursuant to an existing collective bargaining agreement. What's an example of how it could affect the rights pursuant to an existing collective bargaining agreement? Well, if a bargaining agreement has a process for routine employee evaluation, where a human being is sitting down, a human being, usually a supervisor, is sitting down and evaluating or maybe disciplining that employee, potentially the use of artificial intelligence in that process, whether it would be to assess evidence or maybe generate documentation. I think there's a case that there could be some pushback by adding AI to that process. So this is something, as institutions are thinking about, well, where can we use AI to save money? HR functions might be one of them. For civil service institutions, I have to urge extreme caution. I'm not saying don't do it, but paying attention to this law is going to be critically important. If you have to follow civil service, you now have to think about this. The next piece here is the existing representational relationships among employee organizations or the bargaining relationship between the employer and the employee organization. That's a much more loosely defined thing to avoid. But it's really, it's again talking about the relationship between labor and management. But really now, so they vagued us a little bit here, but then they really get specific. And again, I'm on page 2 of the materials, item 5, but it's the same thing in case you didn't have time to print that out. So what is forbidden? The use of such artificial intelligence Freudian slip, systems will not result in discharge, displacement, or loss of position, including partial displacement, such as reduction in the hours of non-overtime work, wages, or employment benefits. In other words, if you are in a civil service environment, you can't say, could we take some of the tasks that are being done by our full-time permanent employees and transition those to part-time employees who are augmented by AI? The answer, starting July 1st, is going to be no. It's 2025. I think it should say 2025. So see how this law, and you'll see how the law uses that definition. But you also cannot transfer existing duties and functions that are currently performed to any system, to any AI system, which is why it was so important that they defined AI system. And then moving on in that, the use of artificial intelligence system shall not alter the rights or benefits or privileges of any collective bargaining unit membership status or anything. Basically, the AI is not going to come in and replace civil service workers in any capacity. That is important. So when it comes to impact and template language, So clearly this law was passed to guard against destabilizing the civil service workforce, which, because of the rapidity at which change can happen with AI, uh, there's a clear goal here to maintain that stability. What does this mean on a practical level? It's really important for those of you who are in the civil service environment, your boards, or we might have some trustees here as well. So as good fiduciaries, a governing board of a public library or other civil service institution may say, oh, is there any AI that we could use to reduce the impact on our budget? One of the biggest parts of any public library budget is, of course, going to be the budget for personnel, as it should be. What's a library without its people? So one of the things a board has to be very aware of is that not only is that a dangerous road to go down, it is an illegal road to go down. So there can be no discussion of, oh, can we cut the workforce by supplementing some of the things with AI? In other words, in the civil service environment, AI must be additive. So instead of it being, can we use AI to swap out some workers? The real question is, how can we use AI to maximize the performance of our workers? Are there things, are there things that AI can do to help our workers be more productive, to better serve the public, to be more efficient, but not can we replace workers? Very important. And I'll just linger a second and see if we had anything on that. Hopefully that's being taken as good news if you didn't know about it before. Okay. So number 6, and this is starting on page 3 of the materials. So under our New York State General Business Law, which is if you ever want to visit New York State's General Business Law, it's fascinating. It governs everything from sales of Torah to things like how we monitor AI. So it's all over the place. It's a fascinating rabbit hole to go down. So starting on June 19th, 2025, the New York State General Business Law is going to be watching social media and particularly how AI is being used within social media. Because how does this play into your library, your institution? Well, many of you are in the business, and your library is in the business of not only providing access to information, but being a source for determining the reliability of information. And so I do think it's very important for libraries, especially libraries that are serving the public by allowing computer access, which that's most of you, by allowing computer access in part to social media, or are using social media. It's really important to see what's being requested. Well, not requested, required of social media entities. And as you can see, it's a lot. And I'm not going to read this verbatim, but it is important to bear this in mind. On a semi-annual basis, social media companies are going to submit to the New York State Attorney General a service report. And that service report is going to include the current vision of terms of service. So for those of you who have ever read, the Facebook or any of the other terms of use, they reserve the right to change those terms at any moment. But this is the Attorney General's way of saying, well, we would like to have a record of what terms of service were in place at a particular time. Of course, the Wayback Machine and archives can hopefully continue to serve that function, but topic for another day, sorry. So the current version of the terms of service, a complete and detailed description of any changes of the terms of service, right? So trying to figure out what is the contractual relationship, what are the terms between the end user and the service, and a statement of the current version of the terms of service and how they define the following things. Now, this is one I fully expect there to be some type of litigation, either given the current climate or just in general, some type of litigation over this. But these are defined terms here in the state of New York. So it's a statement of how they're looking for how are these services defining hate speech or racism, extremism or radicalization, disinformation, misinformation, harassment, foreign political interference. You can see the genesis of why this information is being requested on a systematic basis. They are also looking for a detailed description of content moderation practices used by the social media company. And they are going to be looking for how automated content moderation systems enforce terms of service, right? How is AI being used? And again, we're not going to go through all of this, but this, to me, for if you are at an institution that's trying to help people determine what is reliable information, being able to access these reports, knowing that this information is required of a social media company, knowing that this is being cataloged is very important. This could become very, very useful. And let's see here. I just want to get to, as it's quite, there's a lot, it's important to go through, but the takeaway at the end is that the Attorney General is going to make all the terms of service reports submitted available on a repository. I don't know, maybe this is going to become someone's job at some point. It should be, right? This sounds like a job for a librarian. So cataloging all of those reports and making them available. And again, I think this can be very useful depending on the use that your own institution makes of social media, how you want to educate your particular community on social media literacy, on good social media hygiene, whatever you want to call it. I think this is going to be a very, very useful repository. And again, if we take a look just at the part of this is going to be disclosure of how AI is used. So just bearing that in mind, and maybe if for those of you, so some institutions, I'll say this, some institutions have really gone on a social media diet. They're not doing much. They're actually using their website. If they have information they want to push out, they're back to using their old school website and maybe retransmitting a few things on social media, and they're not being that interactive. Other institutions have really doubled down on making sure they're using social media to engage the public. There's no right or wrong answer there. I do think the more your institution is using social media, it is important to keep this in mind and maybe even add an annual review of these reports to your social media policy, because these reports are going to be helpful in deciding which social media to continue using or how to use that social media. So continuing on that, New York State election law now has a definition of materially deceptive media. And as you can see in item 3 there, that includes media that might be created by artificial intelligence. So if your institution is generating content, it is important to realize that, again, content that is generated by artificial intelligence has a flag as being potentially materially deceptive. This is why it's so important to start with the human, end with the human. The AI is it can be a wonderful tool for creating some amazing things. It should not be the final arbiter of the product. And it has been flagged, as you can see, in different parts of our state law. It is flagged as deceptive. That doesn't mean it shouldn't be used. It just has to be used with caution. Okay. Now, most of you are at either private institutions or you are in different types of libraries that are quasi-governmental, right? You're a municipal library, a school district public library, a special district public library. If you're at an Indian library, it's actually, you have some sovereignty that you should definitely be verifying to what degree the laws I'm mentioning pertain to the operations of your library. That is something to speak with your legal counsel. But it's important for those of you who are either at a state institution or you're working with state institutions, it's important to be familiar with this next factor we have here, factor 8, which starts on page 5 of the handout, which is that under state technology law section 403, use of AI by state institutions, and as you can see now, that is any department, public authority, board, bureau, commission, division, office, council, committee, or officer of the state, but not the legislature and not the judiciary, nor a municipality. So this is not going to apply to the majority of people who are listening. However, it's really important because for those of you who work with state agencies, and many of you do, um, you have to realize that they are going to be obligated by this in their use of AI, but also because I think if you are looking for some language to be careful in your use of AI, this here is because part of the takeaway for today is having some template language. There is some really good language and practices in this state technology law section 403. And so any state agency, so again, this is not going to apply as a mandatory, as a requirement for most of you, but there's some really good thinking in this law. And I would encourage you, as you were thinking of if your institution is going to start not experimenting with AI, but really using it for some important functions, here, and and that could be how you assess whether or not to do a particular program, how you're generating your signage, how you might be promoting things, all that. There's some really good processes here. So I just wanted to spend some time reviewing this. So number one, you're going to have the state has to, the state agency has to, but anyone can have a program for assessing the AI by assembling the following. So number one, describing the objectives of having an automated decision-making system. So any type of, if you're making, again, if you're doing any type of decision-making, why are you using the AI? And I would say not even just in decision-making, but just if you are deciding to regularly invest in and use AI, why? What is the purpose? What are the objectives? And then evaluating the ability of that AI to achieve its stated objectives, whether it's decision making or otherwise. How good is the AI? And remembering that fourth rule we talked about at the beginning, which is always assume the AI you're using is the worst AI that you're ever going to use. But can this product actually do what it says? And putting it to the test, especially before any type of investment is made in a product or service. And then having internally a description and evaluation of the objectives and development of the AI and its process, including a summary of its underlying algorithms. How does it do what it does? If you don't know how it does what it does, there's a risk there. And what design and training data are used to develop the process it's undergoing? And having a process to test for accuracy, fairness, bias and discrimination, and assessing if the automated decision-making system produces discriminatory results. So having some way, aside from the AI itself, to say, okay, is the end product of the AI creating any type of biased result? Very important to keep a lookout for that. And then, of course, what are any cybersecurity vulnerabilities? So, and I'm trying to put this into a library context. If there was ever an AI interface that was going to be developed so that people could visit you could have patrons work with the AI to say, help me decide what parts of the library, what library services I need. And people feeding in their information and the AI saying, oh, you would love to come to this program, you would like to do this, something like that. Making sure that that system, having a process to make sure that that system is free of any unintended bias. Also making sure now, most of your organizations are not going to have be addressing public health concerns. I say that, however, for those of you who might be using AI for instance, a digital navigator program, or in the context of people getting information or accessing information about public health, that this could be a factor. But also making sure that any reasonably foreseeable misuse of the system, that you have a backup for that, safeguards.
Well,
Yes.
question. What is meant by automated decision-making system? Does that include something like ChatGPT or something more specialized?
That's a great question. So it could. So if we go back to so, and what is decision making? Decision making is we've used the AI to assess whatever. And after that process, a decision has been made, as in, we will do this program, as in, we will advise this particular resource. In the context of state government, it would probably be things like, and it could be, I'm just I'm just speculating, but it could be things like where to invest certain resources, how effective certain laws have been, all the things that AI can be used for, customized searches and then processing and assessment of data. And then at the end result, it's not just raw data that's coming out, but an actual recommendation or decision. So I like this rubric, or this what they have put together here, even to just remind us of when we're using AI, even to just generate not something that's decision making, but something that's content that's going to be relied upon in any way. I like this as a start. However, but truly when they say decision making, they're meaning there's going to be some kind of assessment and then some type of decision is happening. And yes or no, or go this way, some kind of strategic direction. So I think this is a good standard to consider adopting, just because this is very, very, if your institution decides to use AI, especially for any type of decision making, again, feeding the information in, letting the AI conduct the analysis per the specified parameters you gave it, and then seeing it come out at the other end with some type of decision or recommended course of action or product that will impact the public, right? Remember that definition, AI is something that at the end is going to impact the public. I think using this until there is further guidance is a good start. And I don't say this to discourage institutions from using AI, but rather to make sure that they have some type of, even if you don't have to follow this because you're not a state institution, having some type of standard for setting up the safeguards that you really want to have in place.
I've got a question. I've seen where large databases are using AI in their designs and structure. Would Factor 8 laws affect our ability to access them through the New York State Library?
So who is using it? Right at the beginning?
Factor 8 laws?
No, right at it says the first part was somebody is using AI to do. Who was the entity? Right at the top.
Ashley Pickett says that she has seen where large databases are using AI in their designs and structure.
Okay, but I guess who is the user? Is it at libraries or?
Large, I
Okay,
can't
so
answer that,
maybe
Gold.
large databases, we mean like as in uh OCLC or like databases that are serving libraries. So yes, actually, and if I imagine there's going to be someone out there's going to help me out with the question.
The answer is EBSCO, et cetera.
Oh, et cetera. Right. Okay, that's right. Yep. So number one, if the state is entering into the contract, absolutely. So this is absolutely going to have an impact on that. Now the obligation is on the state institution, not on the vendor. However, what I like to do when I'm working on a contract for a particular service, and I know it's in a highly regulated area, and many of you will see this in other, not just pertaining to AI, but in other contracts you've dealt with, is to say, okay, we have an obligation under the state technology law, and you, vendor, are going to give us your assurance that everything you're doing is going to lend itself to our obligations under Section 403 of the state technology law. And savvy vendors are going to know that that's going to be an expectation. That said, this area is moving so fast that might not have happened yet. I have not seen a contract yet that references this, but it is new. So, but absolutely, anything if it's a state contract for an AI, either an AI service or a vendor that's using AI, some of that obligation is the state is going to have this obligation that we just reviewed and absolutely should be using its contract to either impose that obligation on the vendor or to make sure that information related to the performance of services is making it so this law can be followed. So as an example, if the state health department was going to be using a database to help track and analyze numbers related to public health issues, they would absolutely be having to follow this. And I wouldn't be surprised for some of you who are maybe getting, if you get a subaward from a state institution, if you'll start seeing some of these obligations flowing through into those contracts. So yes, awareness of this is very important. And making sure, so on that note, we're not covering it today in the double checking time in the 12 minutes we have left, although I will be taking questions afterwards. For those of you, the institutions out there that are thinking, yeah, we want to do this, or we know that we're going to be involved in a contract where this could be happening. I'll talk to the board members out there and the leaders, making sure that training so that you have employees and key employees who have the competencies to do a lot of this, not to actually necessarily perform all the work, but to recognize how to get this type of analysis and safeguards in place is going to be important. And people can learn it on their own as long as they're given the, sometimes that budget just means that they're going to take the time to learn it on their own. They're going to take the courses, they're going to do that work to get to the point where they know that AI can be used responsibly. And for institutions, again, that are considering using it or already using AI, someone's job description should probably have responsible use of artificial intelligence, right there in the job description, because this is such a big topic and it's only getting bigger. Okay, so, and I didn't put this because I'm assuming that all of you are engaging in fantasy sports, but no stigma. It's legal, so maybe some of you are, and maybe I would be curious if anyone wants to answer in the chat. Do you have policies on people engaging in fantasy sports using library resources, so your computers? And if so, I'd just be curious, is that allowed, disallowed? It is a form of gambling. However, it is a legal form of gambling. And because it is a legal form of gambling here in New York, fantasy sports, fantasy football, etc., the New York State Gaming Commission has been on top of this, and they've provided, I think, some really useful language for policy development when it comes to AI being used to supplement services. Again, especially if you're in the civil service environment, AI should not be used to substitute for the human worker. That's illegal. However, if it is supplementing, there's some helpful resources here. There's some helpful model language. And so here's what was required by the New York State Gaming Commission. So a fantasy football, etc., fantasy sports game will not employ an artificial contestant. Use the software to employ an artificial contestant within the fantasy sports, unless it is explained clearly, right, in the help menus. And all computerized contestants must be clearly marked in contests so that contestants are aware which contestants are not human. And I think that is a really good place to start. Good job, Gaming Commission, for coming up with this one. So, letting people know, and I guess I skipped over A here, right? The software may employ the use of artificial intelligence to facilitate participation for demos, free contests, or training modes, which for those of you who, I do not play fantasy football, but I game in other ways. And yeah, that kind of makes sense for a training mode or a demo. But disclosure that the artificial intelligence software is being used in B, and that all computerized contestants are marked clearly. So I don't know about you, but when nowadays a lot of customer service online is handled by AI. And when it's identified as I have a fairly positive reaction. I'm like, okay, I'm working with the AI. If it's good AI, I'm going to actually have a pretty good experience from the customer perspective. And it's when I suspect I'm dealing with an AI, but it hasn't been disclosed to me, that I start to get that like sort of creepy, annoyed feeling, even on a good day. So I do think it's important for any institution that's using AI, especially public serving institutions, to think about having disclosure. It is, I went through and did a thorough search. It is not required by law or regulation right now, that type of disclosure. So for instance, and I'm not suggesting doing this, but if your library were to have an automated reference desk that was powered by artificial intelligence, civil service folks, starting in July, as long as you haven't, replaced the human being who was working there, this could be allowed. But here is a model for disclosing and letting people know, when are they dealing, when are they getting service that is not being powered by a human. And there's a nice model here, and there's a lot of good reasons why we would do that. So talking that through. So, and I think it's important if someone says, well, why do we have to disclose if we're using an AI? I think it's important to say, well, even fantasy football has to disclose, when there's an AI. So here, we'll go there. So here's some model language, right? The library does not employ artificial intelligence to provide reference desk services, except, right? So this would be if you're going to be using it. We talked about using the AI to augment the human services. So letting people know the library does not employ artificial intelligence to provide reference desk services, except A, the library may employ the use of artificial intelligence to assist with the search and refinement of queries. B, the use of artificial intelligence software shall be managed in a way to preserve patron confidentiality. And C, all final output shall be reviewed and conveyed by an employee, right? Closing the loop. And so that's some sample language for if your library did decide to use AI to augment, and maybe you already are doing this, but making that disclosure and building in that added obligation, no matter what tool is being used, to preserve patron confidentiality. Very important. So that's the end of the session. And oh my goodness, I actually brought it home a little bit early. So what we'll do is I'm actually going to put us on the definition. So everybody close your eyes for a minute. I'm going to slide page very quickly, because I'd like to go back to the definition at the beginning. So here we go. And that brings us to factor 4, and we'll talk about New York's definition of AI. And Lester, do we have any questions?
Someone asked to see that last slide again, but I don't know exactly when they asked that,
Okay.
So
All right.
I
Well, if
apologize.
anyone wants to, I could definitely go back there, just put it back in, which one do you want to see? The all the content, the verbal content, the textual content is in this takeaway as well. So artificial intelligence system, given set of human defined objectives to make predictions, recommendations, or decisions influencing real or virtual environments that, when used, may directly impact the public. This is the important thing to keep in mind. There's a lot of other uses of AI, but when you're using an artificial intelligence system, that is when there's going to be some heightened responsibility and obligation.
We have a question. Am I allowed to potentially share the recording and handout with my librarian colleagues?
Yes, absolutely. So the materials are licensed, speaking of copyright, the materials are licensed for internal use. So I guess please don't just post them anywhere and send them anywhere, but definitely for internal use at your institutions, to have the conversation that that we've been having today. I want to mention, so this is a big overview. I hope people aren't feeling overwhelmed because we really did go in a lot of different directions. I think if you think about, for instance, a personnel handbook might be one place where a focus would happen on AI. And in a personnel handbook, having a definition of AI and then making it really clear. Some libraries may and other institutions may make a decision, either due to risk management or simply the personality that they've decided that their institution has, that there will be no use of AI. That doesn't fit with the 4 principles we reviewed, but it is definitely an option. And it would be something that would be debated at length. And maybe that decision would be made because the institution knows it doesn't have the current capacity to engage in the kind of risk management that we reviewed in section in section 8, right? That they don't have the ability to put those safeguards and monitoring in place. And so until they do, they're just going to say, please don't use AI because we can't guarantee that we won't have an accidental copyright violation or accidental bias. And until we're set up to do that, we're going to tell our employees not to use it at all. So that would be one of the places where the rubber would hit the road on this. And it would be very simple. I think in adopting a policy like that, it's very important to say the why, because some employees are going to want to be innovative. They're going to want to use artificial intelligence to the benefit of the institution, to the benefit of the served public. And they can make the case, this should be, the use of artificial intelligence is something that any institution should be constantly reevaluating and debating. Always trying to invite it to the table, but also making sure that if it's invited to the table, that doesn't mean it's being used for everything without thinking about how do we do this safely? How do we resist the influence of bias? So I'll see if there's any other questions.
Not yet.
Okay. All right. So I think the other place to look at, aside from a employee handbook, this would be a good time to take a look at if you are at a place with a union, and if union negotiations are coming up, probably. So if you have a union contract that's been in effect for like 3 years, maybe it's due for expiration. It probably doesn't have any mention of AI, but you might want to be ready to discuss it at the bargaining table at the next time. And I see a hand from Claire.
Sorry, since I'm a panelist, I can't use the Q&A thing, but I'm really curious if there's any kind of legal precedent about not letting new technology potentially take a job away. Like that feels like a big bag of unintended consequences.
Absolutely. And it's such a big bag of unintended consequences that for the civil service employees here, it can't happen. It's against it will be against the law. That's huge. And I think, there's, as always, when you have public employers embracing a set of norms, I do think there's going to be some probably some trickle effect, right? However, other than that, is there a legal precedent to not have that happen, or any legal basis in the private sector? There's a ton of, obviously I'd want to say contracts, policies, union agreements, even with, with private employers, there's a ton of things that might stand in the way of that. But as far as something that's as concrete as Civil Service Section 80, not yet. Not yet. Man, that's a downer note to end on. But we are officially at the end of the 1 hour, the 60-minute session. I want to thank everybody. I think we're going to stop the recording in just a minute, and we will take some further questions. But as far as doing your time and getting your certificate and reviewing all the materials that we had on deck for today, you have done so. And thank you very much for your time and attention.